This is Twit.
Eric Goldman characteristically has a brilliant summing up and sort of, here's what you should be thinking about post over at Forbes. He calls it 4 Unanswered Questions from Aereo's Supreme Court Loss. Let's wrap up our discussion by considering his unanswered questions. The first one is, and he says the court leaves this unresolved. I wonder if you guys agree that who took the legally significant action, whether it's Aereo or Aereo's customers, ever got resolved in this case, and does it matter? So, Evan, what do you think of that one?
Well, this is where the Aereo decision does sort of depart from our ordinary thinking when we think of it in terms of internet law or as an internet law issue, because, again, the court considered 2 questions. Was there a performance, and was that performance public? And in characterizing it as, yes, Aereo as the intermediary here, remember, the court held that it did indeed perform the work, and so that it could be directly liable for copyright infringement. So this is different than Betamax, and this is different than Grokster, in as much as in those situations you were going after the provider of the device or the service, the platform, as in Grokster, the intermediary for secondary liability. So here we've got Aereo being treated as the intermediary, the provider of the service, in the question of its liability for direct copyright infringement, it being the one to take the act that constituted infringement of the copyrighted works owned by the networks and the broadcasters. So that is one thing that's really at the first blush very shocking about this, and the part that could, if there is going to be any effect on industry and the marketplace, it'll be that question right there, because what this case does is expand the class of providers of services, which could in some senses be thought of merely as online service providers as defined under the DMCA, for example. They are now are at greater risk of infringement for direct copyright liability for direct copyright infringement. And a point that Professor Goldman makes later on is like, well, maybe even this won't result in greater liability for those intermediaries, but you can be certain that there's going to be a lot more litigation in this space, just like there was, just like in many more copyright cases now, you see inducement post-Grokster. So Aereo wasn't the one who instituted the action. It didn't undertake the volitional act, the volitional conduct. And this is what I see as the real thrust of Scalia's dissent. Aereo is just the provider of the services here, yet it is being held directly liable because, well, it looks like a cable company.
Right. And to that point about there being more litigation, this is existing litigation, but the case is already being raised by Fox in its case against Dish involving its Hopper and streaming services, has already run to the Ninth Circuit, saying that in light of this decision, Dish's streaming is going to be a public performance that violates. It seems like here there might be a twist because they have some contractual bars against streaming the works. So that's one to watch, but it's already coming up in people's litigation where someone's going to say, "Hey, under this case, you've got a public performance on your hands." I'll take the next one from Professor Goldman's article. Is the DVR as a service legal, either the aspect of Aereo's business or, say, a DVR under the Cablevision case, the Cartoon Network versus CSC case, as it's captioned, like the Betamax case, which has a different caption, Sony versus Universal, can confuse people. It confused me when I was searching through the opinion. I'm like, wait, where's Cablevision? It had to have come up. I wanted to go right to that discussion, and I couldn't find it because, of course, it's not called the Cablevision case when a court cites it.
Well, I don't think the majority does cite it anywhere. Actually,
they do cite it, but they treat it, they just blip right over it.
Okay.
And they also make a point at the beginning of the decision to say, let's see, did I quote this in our little rundown. Yeah, it went out of the way to say that the DVR aspect of the business was not before the court. Their specific language was the subscriber may instead direct Aereo to stream the program at a later time. They were talking about how it plays in almost real time. But that aspect of Aereo service is not before us. So, careful to keep their hands off the DVR aspect. But I don't think personally that the DVR aspect could survive this decision. And that's what Professor Goldman's question was. Cablevision actually contacted him after he published his Forbes post to say that they thought the opinion protects their DVR service. Their press statement says, "We're gratified that the court's decision adopted a sensible middle ground, holding that unlicensed retransmission services like Aereo violate the copyright law while protecting consumer-friendly cloud-based technologies such as RS-DVR." Professor Goldman goes on to say, "I don't read the opinion as charitably as they do, and I don't think I do either." Mike Masnick published something that hits on some language in the decision that the court uses that was contemporaneously perceptible. And Mike thought, well, okay, so that must mean if the images and sounds that must modify by people watching. So contemporaneously perceptible by multiple people would equate to a public performance. And if Aereo or some other hypothetical service just use some kind of algorithm to ensure that nobody could be watching the same program at the same time, then maybe they've got a legally viable service on their hand. As I read through the opinion, I don't think that's what contemporaneously perceptible modified. I think the court was talking about sounds and images comprising a performance being perceptible together. That was what was critical for the court in finding that there was a public performance. And so I don't think that just separating the viewing by the customers is going to pass this court's test. Really fascinating question raised by Professor Goldman. I'll kick this one to you, Bennet, is the impact of this case on inline streaming. Professor Goldman posits that since we're just not going to look at the technology behind the scenes, if it looks like a unicorn and sounds like a unicorn and is a duck, then maybe inline streaming is a duck too, because it doesn't matter that everything going on behind the scenes technically makes it not a copyright infringement. What do you think of that one, Bennet?
I mean, and that's the issue. I mean, the fact that saying that we're not dealing with DVR type service. Well, how does DVR aspect of Aereo survive? I think the Supreme Court decision is definitely going to hurt innovation in this area. It's going to make it much harder, and it's anti-consumer. I mean, this was something that benefited the consumers, and I don't think it's really they spelled out it in a way so that future people venturing into this space have a roadmap for how to do this without violating copyright laws. More or less, if they do something that looks like it's a cable system, they're going to get nabbed. And so there really isn't how do you innovate around that?
Yeah, the tragedy of that, maybe having tiny dime-sized antennas is not the most technologically efficient way to approach this problem, but coming up with new ways to approach delivery that work better than the systems that are in place now is something that you would think the law would want to encourage. And whether, this particular one is it or not. And I fear for what this opinion will do to coming up with such technologies, even on behalf of the cable companies, if they were to want to take a different approach toward delivery of their content. They may find themselves hamstrung by this decision, which leads to Professor Goldman's last question. Will this opinion chill innovation? What do you think, Sonja?
Well, that's always the concern when you have, the advantage of formalism with Supreme Court opinions or legal opinions in general is that people are all on the same page. They understand, here's the text, this is what we're supposed to do, this is what we're supposed to follow. But when the court says, but if it kind of looks like a cable company, at least to the uninformed user just sitting there, then we're going to call it a cable company. Suddenly, all bets are off. And so we could have innovators out there who have come up with new ways, or in the future will come up with new ways, that they say, well, I look at the text of the copyright law, this looks fine to me, but to someone sitting on their living room couch, it might look like a cable company. So am I in trouble now? And should I continue investing time and resource and my expertise into innovating this new technology? And so that's definitely the harm that comes with the court, again, choosing substance over formalism in this kind of situation.
So the question that kept coming up in the run-up to the case, and that I think remains unanswered now, along these lines is, okay, so your Dropbox or your Google Drive or your anything that stores customers' data in the cloud without doing close packet inspections and content ID matching of that data. What do you make of this? You know, are you now in jeopardy, you and your cloud service? What do you think, Sonja?
To me, that's the $1 million question. I mean, I just wish I know. The court went out of its way to say, you know, this isn't going to apply, or we don't think this applies to any other kind of cloud-based computing or streaming. The court sort of charmingly, one might think, went back to a 2008 dictionary to tell us what streaming means, and so they tried to carve that out, but it's a little hard looking at the opinion to know truly, you know, what is the future there. I don't have the answer.